Thank you,
Okay, we're
Jenna.
ready.
Hello, Nevada Wildcard. How are you? Good to see you. Congratulations on making it to finals. My name is Caitlin Johnston. I am an attorney in New York City, but probably more importantly, I'm a We the People alum. So I did this in high school when I was growing up in Indiana. Did not make it to nationals, so you've already bested me. Best of luck today. We'll finish introducing ourselves and then I will hand it over to you.
Good afternoon. I'm Ed Murphy. I'm a Superior Court judge in Tacoma, Washington, and I want to add my congratulations to your team reaching the national finals, and congratulations to you, to your coach or teacher, and also to your parents and family. I look forward to your presentation.
And I am Edward Volpe, an attorney in Denver, Colorado. Thank you for all of your hard work during these 2 semesters. I look very much forward to learning how much you have to say about the question that is put before you this afternoon.
Very good. Would you please introduce yourselves and your teacher?
It's awesome to meet you guys. My name is Conrad, Conrad Drews. I plan on attending University of Nevada, Reno for political science. And outside of We the People, I participate in our robotics club and our tennis team.
Good afternoon, judges. My name is Laura Flynn. I plan to study psychology in the fall at University of Nevada, Reno. And in addition to We the People, I'm the captain of my soccer and softball team and an officer for the National Honor Society.
Good afternoon. My name is Nicholas Pietzka. In the fall, I plan to study economics. And in addition to We the People, I'm on the National Honor Society and the captain of the cross country and track and field team. And we are here with our teachers, Milton Himes, Sean McClelland, Ashley Nickel, and Ryan Spisman.
Amazing. Decorated group. Thank you. And thank you, teachers and coaches, for prepping them. Okay, you know we're doing question 2. I'm going to read it through very quickly. And then when I finish talking, you can start your own clock by jumping into your prepared remarks, okay? A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on interference. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a National Bill of Rights as compared to state bills of rights? And what are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
John Adams once wrote, "Liberty must at all hazards be supported. We have a right to it, derived from our Maker. But if we had not, our fathers have earned and bought it for us at the expense of their ease, their estates, their pleasure, and their blood."
We agree with Thomas Jefferson and John Adams that a written Bill of Rights is the most fundamental component of keeping the government accountable to the people. To draft the Bill of Rights, the founders analyzed Britain's use of an uncodified constitution, which granted Englishmen a set of liberties. However, British officials did not abide by this common law, and there was no clear outline of liberties that the colonies could hold England accountable for their usurpations.
The founders also relied on the philosophical writings of John Locke and Rousseau, which illustrated that the government's purpose was to protect one's inalienable rights through a written document. They looked towards state constitutions such as Virginia's Declaration of Rights, which effectively protected the people from the government's abuse of power.
An advantage of a National Bill of Rights is that it is a unifying document which sets a baseline of liberties and a higher law through the Supremacy Clause. A disadvantage is that the process of amending it is tedious. State Bill of Rights are easier to amend, and they better fit the cultural landscape and the needs of the constituents within it. Justice Brandeis referred to the states as laboratories of democracy because they can test certain policies before they are granted nationwide.
The expediency of state constitutions allow for the addition of emerging rights, which progress with current culture. This leads to the adoption of positive rights like education, universal adult suffrage, and same-sex marriage.
A disadvantage for both national and state bills of rights is that they are not a one-size-fits-all document. And because of regional diversity, rights don't always meet the needs of every person. The biggest problem with state bills of rights is that the variation among states is too great. Someone in one state may have completely different rights as a person in a neighboring state, which violates the principles of the 14th Amendment.
One right that shows the disparity of liberty between the states is the right to bear arms. In Article 1, Section 11 of Nevada's Declaration of Rights, the right to bear arms is protected for uses of security, lawful hunting, and recreational usage. On the contrary, the Californian Constitution contains no provision which protects the right to bear arms.
We agree with Justice Brennan when he wrote, "The framers of the Bill of Rights did not purport to create rights. Rather, they designed the Bill of Rights to prohibit our government from infringing rights and liberties presumed to be pre-existing. Negative rights, which restrict the government's actions, are the most fundamental to protecting liberty because they are based around the natural rights philosophy, the idea that everyone is born with fundamental rights that cannot be abridged. The First Amendment is a prime example of a negative right because it states, Congress shall make no law, and it can only be regulated under circumstances determined by the judiciary."
While negative rights are the most important to preserving liberties, positive rights are fundamental to advancing the common good and quality of life. Positive rights require the government to act in a specified way to guarantee liberties, such as access to a speedy and fair trial, healthcare, and education. Some argue that negative rights sit on positive rights because a person cannot exercise his or her rights to speech, religion, or assembly without education or basic means of survival. As the German Supreme Court, the Bundesgerichtshof, appropriately summarized, the right would be worthless without the actual ability to make use of it. Thank you.
Great, thank you very much. Please put your notes away and we'll move into the follow-up portion. I'd like to pick up, you mentioned the First Amendment as an example of a negative right that could be regulated by the judiciary. So tell me more about that. What limits are currently placed on that particular right?
We can look to Brandenburg v. Ohio, where the court has limited speech that may incite violence.
Okay.
We can look at Chicago Police Department v. Mosley to recognize that all limitations on speech must be content neutral. In a more localized area like schools or in the military, as set in Tinker v. Des Moines, it has a lower standard to be limited. In Tinker v. Des Moines, the standard was if it materially or substantially interrupts the educational duty of the school.
Thank you.
What is the difference, if any, between rights that are added through the amendment process and those that are established by a court decision?
Rights that are established through amendment are a little bit more open to interpretation, but on the other side, things that are set by the court are more set in stone and they're very clear.
I would say that rights established by an amendment do receive strict scrutiny because they're described as fundamental. However, we can also see that through court's interpretations, such as in cases of Harper v. Board of Education, the court ruled that the right to vote is a fundamental right that receives strict scrutiny. And although this wasn't mentioned in the first 10 amendments of the Bill of Rights, it was affirmed in judicial decisions.
Which appear to be more longer lasting, the actual amendments themselves or the rights established by court decisions?
The amendments themselves seem to be more open to interpretation. We've seen how they've been influenced by culture throughout history, while penumbra rights are usually more defined because the courts are giving more information and how they should be applied.
I would argue that the amendments in the Constitution are living, and an example of this would be in Griswold v. Connecticut. The court interpreted that under the Fourth Amendment and Ninth Amendment, we do have a right to privacy, which, although it is not explicitly mentioned in the Bill of Rights, we have that right, which was used in subsequent cases such as Roe v. Wade to protect the right to abortion.
Thomas Jefferson called the Constitution a ball of wax ready to be shaped by the judicial branch, and I agree with that. Penumbra rights, however, are more defined by the judicial branch and more set in stone because they are a part of a precedent and a court decision.
would agree. Sometimes the judiciary gets it wrong. For example, in Plessy v. Ferguson, that decision was overturned later by Brown versus Board of Education, but there aren't very many circumstances where the Supreme Court will flip-flop its decision.
Very good. You pointed out in your presentation that the ability to amend and change state constitutions and bills of rights leads to a great deal of variance between the states. Can you think of whether or not individual states have the power to make legal something that would be a federal crime or a crime in the neighboring state?
Absolutely. In Nevada, marijuana is legal, while it is still federally illegal.
In addition, Nevada's constitution was recently amended in 2020 and under section 21 to change the wording to have the state recognize marriage despite gender, even though this right was recognized federally under Obergefell v. Hodges. Some states still haven't amended their constitutions. So although it is protected federally, some states haven't changed their rule of law to match the federal level.
Under what circumstances could somebody lose the rights that the Bill of Rights or our Constitution generally grants them? When can you lose those rights, if at all?
During times of war, they can be limited more than during normal times. You can see like draft cards and being burned can be limited more during a war.
We can also see that the right to vote, while if you have committed a crime and you are in prison, can be stripped away from a person.
In addition, the court upheld the case in Korematsu v. United States when during a wartime, the executive order from President Franklin Delano Roosevelt restricted the 14th Amendment rights of Japanese Americans. And the court confirmed that this was okay, even though it was stripping them of equal protection.
What does the panel think of that wartime exception?
I don't approve of it. I think that it was an absolutely over-exercise of the rights of the executive, and it absolutely it compromised almost every right in the Bill of Rights. They were given no due process. They were limited in free speech. They were unable to exercise their penumbra right of travel.
This shows, oh, sorry, go.
Government has a duty to keep us safe. So how do you answer that?
Yes, I would disagree with my colleague. We can see during the Civil War that President Abraham Lincoln suspended habeas corpus to ensure that we could keep it so that he could keep his citizens safe. And I think that sometimes this is in fact necessary.
But there definitely has to be a balance. We cannot just violate the principles of our Constitution and Bill of Rights just because there is a wartime. We do have to find some sort of balance. And the balance is not stripping an entire ethnicity of their constitutional rights.
Thank you.
What rights, either positive or negative, that aren't listed in the Bill of Rights or in the Constitution, do you think should be added? And if so, why?
I would add the right of online privacy because we live in the digital age. We can look to Germany's constitution. They have the right to privacy of posts and telecommunications, which I would add.
I disagree. On a federalism or from a federalist perspective, this is already being taken care of at the state level by things like the California Consumer Protection Act. What we should be doing, however, is instating something like healthcare, which has been incredibly effective in places like Canada.
I would instate an amendment that would protect the right to education on a federal level. We can see that the Universal Declaration of Human Rights state that everyone has a right to education, and 135 countries around the world already guarantee this. And education is such an integral part of our community. We can see that James Madison wrote that the diffusion of knowledge is the only guardian of true liberty, and it needs to be protected as one.
While I agree that's important, over 140 million people or Americans are struggling with medical debt.
Go ahead and finish your thought.
When people are in debt, they have no ability to exercise their education or to use the skills they got in their education.
Great. Thank you. All right. Take a deep breath. You're done. All right. It's good. It's over. You guys did a great job. Thank you very much for preparing a ton of subject matter gets packed into this question. We like it as judges because it's very broad. But that also means that you all have to come with your A game and be ready for any question we might throw at you about the Bill of Rights, which is like a huge body of our, of our historical, foundations, right? So I thought you did a great job. The prepared remarks, you were strategic in how you covered the answers to the questions. I would have liked to have heard, you drew a distinction between the Nevada's right to bear arms and California not having one. Put a finer point on why that's a problem to illustrate for us why that is and drive your point home. If you could have snuck in something like that, I would have loved to have heard it. But especially when we got into the follow-ups, you did a good job just jumping in and bringing us examples, what you knew both at the state level and at the federal level. I liked your 3 different proposals for what rights to add at the end. Maybe you rehearsed that, great if you did, but it was nice to hear each of your different rationales. I was looking for violations of the social contract as being kind of the reason that we might lose some of our rights. You went in another direction with the wartime stuff, which is valid and interesting too. And I think, Nicholas, you probably, one of you cited that if you've committed a crime, you won't get the right to have a firearm or vote. So good job. I will pass the baton to my fellow judges.
Well, first of all, I want to compliment you on your style in the opening presentation. You had a very good pace. Sometimes when people read their prepared remarks, they read very, very quickly, and you did not. And so it was much easier to keep track of and to follow. I don't know if any of you have any plans of going to law school and becoming lawyers. If you do, that style will suit you very well when you get in front of a court with a court reporter. If you talk like some of the groups that we've seen a mile a minute, you will have a court reporter throw something at you to get you to slow down. You did not have that issue, and I really appreciated it. And you finished within time. So I was wondering if that was going to be an issue, but you did not have that problem. You handled everything well. As has been said, you get a lot thrown at you. One of the things, the question that I asked about the difference between the amendment process and court decisions, you talked about court decisions being set in stone. I'm not sure that's accurately, or that's accurate, because as you've seen over time, and somebody pointed that out with Plessy, that decisions can get overturned, and as the makeup of the court changes, that can change as well. But very good job. I really appreciate it. Thank you.
I too enjoyed your comments. I thought you made some excellent points. The discussion of Korematsu may well rank in there with slavery and perhaps the mistreatment of Native Americans with regard to our denial of any rights with regard to particular individuals. Those stand out with great shame and tragedy with regard to our American history. I thought you did a good job of talking about how hard it was to keep the British government from abusing rights in the colonies. And when you look at the Declaration of Independence, there are 27 individual complaints about how the British government had abused the rights of the colonists and why it was necessary, therefore, for them to declare their independence and to form a separate nation. I thought your reference to that was good. I thought the quote on laboratories of democracy was good. You went on to talk about the fact that it can lead to a great deal of variance between states. You mentioned marijuana, and you mentioned gun rights and those kinds of things. And yes, it can lead to conflict between and among states. I love the fact that you referred to a change of the Nevada Constitution that incorporated the right recognized in Obergefell v. Hodges. And I think that was very educational for me. I was unaware of the fact that Nevada had done that. And then we go on to talk about limitations on individual rights. I thought you handled freedom of speech well. Brandenburg, Tinker, and a good deal of current social problems such as debt and freedom from debt. One of the things I would encourage you and your generation to talk about is what rights do individuals have with regard to the internet and the new whole cyber world, which is not something that was created in my generation, but it is peculiar to your generation. I wish you good luck with that. And then good reference to historical documents, quotes from John Locke, quotes from Rousseau, the Virginia Declaration of Rights. You could have mentioned Magna Carta, you could have mentioned the Massachusetts Body of Liberties, but there were a number of documents drafted even before the Declaration of Independence that said individuals have rights and they should be recognized by government. And it was influential in drafting the Constitution. But of course, I don't think we would have had a Constitution but for the 9th and 10th Amendment, which said there are rights that aren't specified in the first 8 amendments. I think that was critical to getting the Constitution ratified. And it has played an important role in the subsequent development of rights because it opened the door for both the federal government, the courts, and the state governments to draft additional rights to be recognized on the part of individuals. But excellent performance. Congratulations to you for your hard work. Congratulations to your teacher. Good luck in the competition.
Thank you so
Thank you
much.
so much for your time.
Thank you.